Good morning.
Good morning, Your Honor. May it please the Court. My name is Jeffrey Loeb. I'm here with my associate, David Glod. Together, we represent the appellant, Francis Bevilacqua. This is, as Your Honors are well aware, the first of the post-Ibanez cases. Begin with this fact, when Judge Long looked at this, he made one statement that really, I think, sums up why we're here and the nub of where, quite frankly, we disagree with him. And that is his statement that my client received nothing.
What did he receive?
What he received, Your Honor, were at least two things. Number one, it is our position that he clearly received record title.
Well, to receive the title, the people he purchased it from had to have title to give to him, correct?
In terms of whether or not he received record title, Your Honor. And from a record title standpoint, there is no question that when Your Honor looks at the record, that U.S. Bank, at that point, having received a quitclaim, a foreclosure deed from itself, from a review of the record, had authority on the record to make that transfer to Fran Bevilacqua.
Chapter 240, Section 1 seems to say that you need to have possession of the property and you need to have a claim to title. It doesn't really say you have to have record title, does it? It says if there's a problem with the record title, but it doesn't say you have to have record title.
I would state, Your Honor, what the case law has made clear is that with respect to 1 through 5, you have record title. It's 6 through 10 where you have legal title. And the distinction that's been drawn, and I would submit that he did receive record title. The other thing that he received is that he received an assignment of the mortgage under Brown v. Smith, and that he has two sets of rights with respect to the property. And that Judge Long's statement and his premise that my client received nothing is where we would disagree with him.
What if we accepted that he received assignment of title, but did not accept that your definition of record title is something that he holds, that is legal record title? So where would that get you if he only had an assignment of the mortgage at this point?
If he only has the assignment of the mortgage, Your Honor, then my client would have the right to foreclose.
He wouldn't have the right to proceed under the tri-title, correct?
I would grant this court that yes, that if this court says that I'm wrong with respect to the issue of record title, but reaffirms Brown v. Smith, and I would ask that if this court does nothing else, it reaffirm Brown v. Smith. It gives my client the right to foreclose and to then take control of that property.
Do you take the position that there's already a peaceable entry with a certificate on file?
I'd like to, Your Honor. And I've read that brief, and I think, quite frankly, that's an open question that this court's going to have to determine as to whether the assignment has to take place before. What we don't know, because of the posture, the procedural posture in Bevilacqua initially, we don't have the benefit, Judge Long did not have the benefit of this court's decision in Ibanez. What we know is that the on-record assignment was recorded after the entry was made. It was recorded after the foreclosure was commenced. We don't know, however, as this court wrote, when the assignment actually occurred. We don't know what pieces of paper exist to show that the assignment may well have taken place before the entry was made. We know that it was recorded before the entry was recorded. We don't know whether the assignment was made, though, before the entry was made. We quite frankly don't know whether or not the assignment was made before the foreclosure process itself commenced. And therefore, that's where I come back from a record title standpoint. When you look at the chain of title, when you look at the recorded documents, each recorded document in and of itself is appropriate. What we don't know is when that off-record transaction may have taken place.
Now, of course, the problem with the record title, as reflected in some of the memorandum, is the so-called Brooklyn Bridge, or I guess since we're here, the Zachem Bridge problem, that somebody can sell somebody the Zachem Bridge and you can record that title to the Zachem Bridge, and then you can do a tri-title and put something in the Boston Globe on page 84 in small print to say, if anybody claims they own the Zachem Bridge, they should come forward, and if nobody does, the bridge is yours.
I would suggest, and I've seen that was in Judge Long's decision and in the professor's amicus brief. The Arnold case that's cited by the amici on the other side puts that issue to rest. What the Arnold case says is record title exists where authority to make the conveyance occurs. In Judge Long's hypothetical in terms of the Brooklyn Bridge, if I were to sign the deed for the Brooklyn Bridge, I clearly do not have the authority on the record to make that. Therefore, I have no record title. And so that, while it's a nice hypothetical, it's contrary to the law of the Commonwealth.
So that if the bank gave Bevilacqua a quitclaim deed today, the problem would go away because the assignment's been recorded.
But the assignment's been made.
The assignment has been made.
Foreclosure.
That's not how. I think, as I read this court's decision in Ibanez, the question is still when did the assignment take place? When did that off-record, as I read Justice Gant's decision, when did that off-record transfer take place? We know we have what may well be a confirmatory assignment of record, but the question is, what did it confirm? Because you still, as I've read it, we still have to show that the assignment took place prior to the commencement of the foreclosure proceedings.
But if the assignment did not take place at the time of the foreclosure, what is the authority that the bank had to foreclose? Why is it different from Arnold in the sense of authority? I mean, doesn't Ibanez essentially say the bank did not hold title to the property, therefore had no authority to foreclose?
No, I would differ, because the question is from a record standpoint, that from a record standpoint, when that foreclosure deed, when everything passes, when the foreclosure deed passes, when everything happens, it appears on record that everything is fine, and that my client therefore has record title. And I think that what Judge Long has done and that what this court may be looking at is really the second case. The question is whether or not my client has record title to commence the action. All my client is doing by commencing the action under tri-title is saying to the land court, there may well be somebody else out there, judge, bring him in here. And then we get to the merits as to who has better title. But
Judge Long's position, his concern is that you didn't, because Judge Long was resting on his Ibanez decision, which focused on the recording of the title. So based on his Ibanez decision, there was no title that the bank had at the time of the foreclosure. So he didn't view it to be an open question as you do. He said it was not recorded at that time, therefore it's null and void. So I don't understand why. I don't understand why you're saying that this record title has consequence. From Judge Long's point of view, he's saying there's no true claim of right. So you're no different than the person claiming the Zachem Bridge, because you have no greater claim of title than a person claiming to own the Zachem Bridge.
And I differ with Judge Long in his analysis, because when you look at the chain, when you look at the various deeds that are of record, that each person who executed a deed had authority because there's a deed before it, and there is a clear chain showing the authority for each person to execute and for each grantee to execute that deed. The question then becomes, who has a better claim for title, Mr. Rodriguez or my client? And that's the issue that should have been litigated next.
But at the time of the foreclosure, as far as we know, MERS had title, correct? Not the bank.
I would differ, Your Honor. At the time that the foreclosure deed was executed, there is no question that the mortgage had been transferred from MERS to U.S. Bank.
At the time of the foreclosure deed.
The time of the foreclosure deed.
We don't know about.
We don't know.
Foreclosure.
We don't know, Your Honor.
Because there was no discovery, and that wasn't.
That's correct. So what we do know is from the record.
So explain Brown versus Smith. I mean, so you have, at a minimum, you've got the mortgage, and the mortgage is in default, and you're in possession. The mortgagee is in possession, right?
Correct.
So what does Brown say then?
What Brown says is that if the if the foreclosure deed does not effectuate a transfer of the fee interest, then at a minimum, it operates as an assignment of the mortgage. Because if you think about it, my client paid $300,000.
No, I understand. So is that all that Brown says?
That, from my standpoint, yeah, for the purposes of today, yes. That what Brown stands for is the proposition that if a foreclosure is defective and does not pass fee title, that what it does is it operates as an assignment of the mortgage.
But if you're right, I assume that you still contend you would have the right to rescission if you wished that.
If we did. And I've seen that discussed as a potential remedy. That's not what my client wants.
Right, but
my client wants the property.
But the mere fact that, in your view, at the very least, there was an assignment of the mortgage does not mean necessarily that you receive fair value for what you paid for. You would have the right to say, I will take the mortgage or I will seek rescission and damages.
That's correct, Your Honor. From a benefit of the bargain standpoint, that my client has that option.
Counsel, I'm afraid your time is up. I thank you very much.
Thank you, Your Honor.
Good morning, Your Honors. Richard Otheimer with my colleague, Ms. Langlois, for the Amicus Mortgage Bankers Association. And first, we thank the Court for the opportunity to participate in the briefing and argument of this important, the Court's first post-Ibanez decision. MBA is a association of not only mortgage lenders, but title companies, law firms, and other participants in the real estate finance industry, and I think it's in a position to provide a helpful perspective to the Court, the industry perspective on...
So let me ask you this question.
Yep.
Let's assume I agree with you that the Mr. Bevilacqua is a bona fide purchaser for value. What does that mean in this context?
If Mr. Bevilacqua is, and we believe he is, a bona fide purchaser for value, that would mean that he has good title. Now, he may have to prove that in the underlying...
Does he have good title or just standing to bring a tri-title action?
Certainly we believe that he has standing. I would say that, without repeating, I would say that I agree with the arguments made by Mr. Bevilacqua's counsel. We agree that the standard for the tri-title action of record is record title, and that record title exists in Mr. Bevilacqua by reason of the deed that he received from U.S. Bank. We also agree with the Brown v. Smith argument that at minimum, if there was a defect in the foreclosure such that U.S. Bank did not own the fee, it would be deemed to pass under, consistent with various other Massachusetts doctrines, equitable subrogation of mortgages, estoppel by deed. Insofar as possible, the courts would effectuate the intention of the parties, and if U.S. Bank did not own the fee, nonetheless, the foreclosure deed under Brown v. Smith would be deemed to constitute an assignment of the mortgage. And I think it was clear, but by the time of the conveyance from U.S. Bank to Mr. Bevilacqua, there had actually been an assignment of the mortgage in July 2006 from MERS to U.S. Bank. But let me address different arguments, because I think there's been some questions from the Mr. Loeb said he really didn't know what had happened other than what was on the record. And Justice Cordy noted that there had not been any discovery. Because the petition was dismissed by the land court without any development of the factual record and without any discovery, and because U.S. Bank, and neither U.S. Bank nor MERS was named in the petition, and putting aside whether they should have been, there obviously hasn't been any development of the record. And as I think Justice Gantz noted, Judge Long relied on his Ibanez decision, did not have the benefit of this court's Ibanez decision. He relied solely on the assignment that was of record and determined that it did not satisfy Ibanez. But we do not know in this case whether the July 2006 assignment was in fact what the court referred to in Ibanez as a confirmatory assignment. In other words, that the assignment had already occurred off record, and that assignment was confirmatory, and that certainly is an issue that can be explored on remand. From what we know about in terms of the mortgage lending industry, what we know from the facts, there's a scant record before the court, but what we know from what is in the record, or what is on the public record that the court can take notice of. And what can fairly be inferred from those documents, I think, is the following. The original mortgage here was granted to MERS as a nominee for Finance America and its successors and assigns. If you look at the language of the mortgage, it says that MERS is mortgagee as nominee for the loan originator and its successors and assigns. And that was in 2005. And in 2005, shortly after the loan was closed, it was part of a securitization trust, a series of pooled loans as this court dealt with in Ibanez and LaRoche. And although the record does not answer this, it is almost certain, based on I've looked at a lot of these securitization trusts, it's almost certain that U.S. Bank has been the note holder of the Rodriguez mortgage since 2005. It has also been, as the note holder, it would be have beneficial ownership of the mortgage. In fact, on the MERS system, and although this court dealt with securitized loans in Ibanez and LaRoche, those did not involve MERS mortgages. As far as I know, this court has never addressed the relationship between MERS and its beneficiaries.
Could you touch on that? Because I'm a little confused about the relationship between MERS and what legal, I guess, for the purposes of the chain of title here, does it make a difference, for example, that they never had the note? Or do we need to know whether they ever held the note? And does it make a difference that MERS is or is not the foreclosing entity? And do we know who was the foreclosing entity?
Well, we know that the foreclosure was conducted in the name of U.S. Bank. We know that the mortgage was of record at the time of the foreclosure, still in MERS. But in MERS as nominee for the original lender and its successors and assigns. And I believe we know, although the record is not fully developed, that under the pooling and servicing agreement for this trust in 2005, there would be language selling the Rodriguez mortgage loan to U.S. Bank as trustee of the securitization trust, language of assignment in the pooling and servicing agreement, but the mortgage would remain of record in MERS, and on the MERS electronic system, an entry would be made reflecting that the mortgage, that the beneficial ownership of the mortgage had been transferred from Finance America to U.S. Bank as trustee of the trust. So that at the time of the foreclosure, and there may or may not be an actual off-record physical assignment document.
Let's assume that it's as in Ibanez and that there is no proof that there was an assignment of the mortgage by MERS to U.S. Bank at the time of the foreclosure. Your view is that even though under Ibanez that mortgage, that foreclosure is void, that Bevilacqua is still a person who is a holder in good course? I mean, you're the person, you're the only person who's written an amicus who takes the position that the purchase by Bevilacqua of a void title now gives him good title.
Well, I would say that the issue of whether the title is void or voidable is perhaps something that this court should examine on a fully developed record. The cases that involve sort of void titles, whether they be forged deeds, certainly there are times when the law says that that transaction has no legitimacy and that it is void. What I would suggest on the facts of this case, if they were fully developed, it would establish that U.S. Bank was the note holder, the beneficial owner of the mortgage, not only had the right under this court's case law to compel an assignment of the mortgage, but indeed under the MERS member agreement would have had the full right to direct all of MERS actions. MERS is a bare legal nominee. And the question is, if those facts are all true, and I believe that they would all be proved to be true, the question is, should that transfer, should that foreclosure, if done at a point before there was an assignment, and we don't know that because there may have been an assignment off record through the securitization documents or otherwise, should that be treated as a void assignment so that anyone in that chain of title that from that date after is basically has nothing? I mean, the court in the in this case, Mr. Bevilacqua has conveyed The WilmerHale brief in footnote 14 says, well, there was enough here that someone should have questioned and been on inquiry notice. In fact, Mr. Bevilacqua apparently conveyed 4 condominium units at this property between his purchase in 2006 and February 2008, prior to the land court's Ibanez decision. Obviously, those purchasers and their counsel and whatever banks made loans to them didn't think there was any problem with U.S. Bank's foreclosure title. And other jurisdictions have been circumspect. We cite a footnote in our brief about void versus sort of voidable title because that problem never goes away. We think that under all of this court's case law about what are the requirements of a bona fide purchaser, these purchasers are innocent. Mr. Bevilacqua, the condominium purchasers, other people in Bevilacqua's shoes, before the land court's decision in March 2009, and I understand I'm certainly familiar with this court's Ibanez decision, but the fact that the real estate conveyancing bar and title examiners all relied on REBA Title Standard 58 suggests to me that in a consumer who purchased at foreclosure or purchased after foreclosure and whose title traces back to a foreclosure with an Ibanez issue, to say that those persons are not entitled to the law's protection, I think is not a necessary result.
Let me go back to where I started if I can. So let's assume I agree with you. This is a bona fide purchaser for value. What does that get us here? Does that mean they have standing to bring a tri-title case, or does that mean that they simply win a tri-title case if it's contested?
It certainly means that at a minimum they have standing and it requires reversal and remand to the land court. If they establish, if the court finds on this record that they are a bona fide purchaser and they have good title, they should win and the court could direct judgment.
Okay, but let's go to that just for a moment. Right. So it goes back, and actually the owner, the prior owner, shows up and says, no, there was not a proper assignment. The title is still mine. What happens then?
I mean,
who wins if that's the case?
Well, I mean, he can litigate that issue, and the court ultimately would have to decide that, whether on summary judgment or at trial.
Let's assume it's Ibanez. Let's assume that's the assignment was not effectuated before the foreclosure. So you've got that legal defect, and you have a bona fide purchaser for value. How do we decide, or how does the trial court decide who wins?
I think if he's a bona fide purchaser for value, I think he would have superior title. But again, at this stage, I think any of these results, either record title is all you need under the tri-title action, or that at a minimum he received an assignment of the mortgage and is entitled, just as in Smith versus Brown, he's the holder of the mortgage who's in possession of the property after the borrower's default. And one thing, the land court didn't consider, obviously there are other remedies that may exist beyond the tri-title step. The narrow question before the court is whether whether the tri-title action should have been dismissed on standing grounds. The court sort of went beyond that. Judge Long went beyond that in his opinion and addressed issues that really weren't presented. But we think that there are a number of avenues to protect innocent purchasers, just as this court foreshadowed in Ibanez and Justice Cordy in your concurring opinion.
Can I ask you one more question, though, before you go, and I know your time is up. Looking at Brown, they talk about the person at a minimum having the assignment of the mortgage and being in the mortgage being in default and that person being in possession. And the court then says she being in possession after breach of the condition of the mortgagor or any other person claiming title under him cannot maintain a writ of entry against her. What does that mean?
It meant that upon a default of the mortgage, the mortgagee is entitled to enter into the property and has a superior right to possession as against the mortgagor. They would, standing in the shoes having acquired the mortgage being in default, the mortgagee, in this case Bevilacqua,
default and possession.
Correct. They would be entitled to maintain possession of the property as against the mortgagor.
Okay. Thank you.
Just one last question. I gather that if you're right, we would have to essentially change Ibanez from void to voidable.
I think it's worth. I was here for the Ibanez argument. I was not on the briefs, and that issue was certainly not. I understand the word void appears in the court's opinion, and it certainly appeared in Judge Long's opinion. It was not a focus of the arguments of the parties in Ibanez, and I think that in my view, the court is free to reconsider that. I would point out that at the oral argument in Ibanez, Justice Gantz, in fact, I believe you asked the question, putting aside the lenders, what about the rights of innocent third-party purchaser, bona fide? In fact, you used the term bona fide. Chief Justice Marshall said, who purchased in good faith, and counsel for, I forget if it was Mr. Ibanez or LaRoche, but Mr. Collier, who actually is on the WilmerHale brief here, said his answer, and we've cited in our brief the transcript, he said they may well be entitled to protection as bona fide purchasers. So that issue, I think, was reserved in Ibanez, and I believe the court should feel free to re-examine it.
All right, thank you, sir.
Good morning, Your Honors. Max Weinstein for Amicus Curiae, WilmerHale Legal Services Center of Harvard Law School. Your Honors, we know exactly when this mortgage was assigned to U.S. Bank. We've included the assignment as it appears as of record at the Southern Essex Registry of Deeds in an addendum to our brief at page 8 of that addendum. And that assignment was executed on July 21st, 2006. It was recorded in September, I believe, 20th, 2006. That assignment is not confirmatory. That assignment purports that MERS, as nominee for Finance America LLC, hereby sells, assigns, and transfers to U.S. Bank the mortgage at issue. It makes no reference to some prior securitization, which it confirms. It purports to be a present assignment of the mortgage on July 21st. And accordingly, Mr. Bevilacqua, in his land court petition at paragraph 8, which is paragraph 4 of the record appendix, pled that at the time of U.S. Bank's foreclosure, MERS had not assigned the Rodriguez mortgage to U.S. Bank. As of what was on record at the Registry of Deeds and as of what was in the record before Judge Long, it was clear, both at the time of the foreclosure and at the time Mr. Bevilacqua purchased this property, that U.S. Bank was not the assignee, was not the mortgagee of Mr. Rodriguez's mortgage when it conducted a foreclosure auction. That renders that transaction void, not voidable. And to reach a contrary result, this court would not have to just overturn Ibanez, not 5 months ago. It would have to overturn an entire progression of precedents, stretching all the way back at least to Smith versus Proven in 1861, which has held consistently that a mortgagee who deviates from the power of sale expressed in the mortgage contract renders the resulting foreclosure auction void, not voidable. In case after case after case, even the merest deviation from the power of sale has resulted in a void transaction, not a voidable transaction. So what if we conclude that Mr. Bevilacqua is a bona fide purchaser for value? What happens? No standing to do anything, no rights, no nothing? Absolutely not, Your Honor. I would not contend that Mr. Bevilacqua has no rights, no standing to do anything. Your Honor, the first thing I would note is that all the amici agreed, notwithstanding claims that Mr. Bevilacqua is a good faith purchaser or a bona fide purchaser. All the amici agree that Mr. Bevilacqua was aware, or should have been aware from the state of the record at the time he purchased this property, that U.S. Bank was not the assignee of this mortgage when it sold Mr. Rodriguez's property on May 16, 2006. Mr. Bevilacqua was aware of that. He was aware of the defect, and he cannot, therefore, be said to even be a bona fide purchaser for value. But even assuming he was, Your Honor. Let's assume he was. Even assuming he was, it wouldn't matter. Because even a bona fide purchaser is not protected against all title defects. And, Your Honor, I think this court actually said it best in Brewster v. Weston. The purchaser, and I'm here quoting, the purchaser of an apparently perfect record title is not protected against all adverse claims. It may be bad because the grantor may have been insane or an infant, or because title has been defeated by adverse possession. All right, a so grantee cannot assume. He's not protected against all adverse claims.
Yes, and he's not protected
against, he can, a void transaction passes no title. And that is, again, I believe a direct quote from Brewster v. Weston.
So going back, I mean, apart from whether or not there was blame that may be attached to Mr. Bevilacqua for not having focused on the failure of assignment, I gather what you're saying is, even if there was no fault at all, he still can't be a bona fide purchaser legally because he purchased a void title, and if it's void, if you purchase it after the fact, you have you have the same absence of right to it as the foreclosing party.
That's exactly right. The bona fide purchaser status is of no avail when your grantor lacks authority or lacks capacity to convey an interest in real estate to you. It matters not that you are the most pure-hearted and innocent of purchasers.
So you are, in this case, you have obviously acquired something, so the land court is wrong to the extent it suggests that Mr. Bevilacqua acquired nothing. He has the mortgage,
Your
all
Honor,
the rights of the mortgagee in possession on a defaulted mortgage.
Mr. Bevilacqua acquired nothing that is of any avail to him in a tri-title action, certainly. Assuming that Mr. Bevilacqua can prove that he has now received an assignment of the mortgage, and I think that assumption will be rather difficult to prove, but assuming he is.
How can that be possible? The bank certainly had the mortgage when it sold the property to him, when it transferred the deed to him, didn't it?
There is an assignment whose validity, I think, is questionable, Your Honor.
So you're questioning the validity of this assignment?
But, Your Honor, I don't believe you have to reach that issue. Assuming that he is the mortgagee here.
In possession on a defaulted mortgage?
Yes, yes. A mortgagee can still foreclose, provided they can demonstrate and prove ownership of the mortgage. And that's why I say that Mr. Bevilacqua is not without remedies and he's not without rights here. Mr. Bevilacqua, and they are rights and remedies that he should hopefully be able to realize at no cost to himself.
And as a mortgagee, he has legal title to the property, does he not? Isn't this a title state?
This is a title state, absolutely.
So why doesn't he have standing to try title if he has the legal title and possession in a defaulted mortgage situation?
Bare legal title is a very restricted concept. If a mortgagee wishes to sell or otherwise alienate the property of a mortgagor, that mortgagee has to foreclose. That is a result.
Or take possession.
Even in possession. Even in possession, Your Honor.
Or take possession.
Or take possession through, yes, absolutely, Your Honor, through foreclosure by entry or foreclosure by action. Those are both options.
Here. He entered 4 or 5 years ago.
And so he must otherwise comply with the requirements of the foreclosure by entry statute, which requires him to record a certificate of entry. And until 3 years have passed from that certificate of entry, Mr. Rodriguez retains the right of redemption.
Now, you had your brief was the only one, I believe, which made reference to the fact that there had been a certificate of entry filed here, albeit by U.S. Bank, correct?
I don't recall whether we made reference to that in our brief, but, Your Honor, if I could perhaps just clarify, only a mortgagee can make entry and foreclose by entry. And that person must be an assignee as of the time of entry.
But when was, or as of the time the certificate of entry was filed?
No, as of the time of entry, Your Honor.
Why is that?
Because you have to be a mortgagee to foreclose. And
But
when
the
you make the
certificate
entry, you are foreclosing.
I thought it begins to run when you file the certificate of entry.
The right of redemption starts to run after you file the certificate of entry. But the act of foreclosure is the entry. And to take the act of foreclosure, you must be a mortgagee. That is this court's central holding in Ibanez.
The act of foreclosure is the entry, even in a foreclosure by entry.
Yes, Your Honor.
It's not the certificate of entry which triggers the right
that's
of
necessary
redemption.
to perfect it and complete it, Your Honor. But it is not a mortgagee may foreclose by entry, not someone who expects to receive an assignment at some later date of the mortgage.
So your view is that Bevilacqua, upon being assigned the mortgage, or upon acquiring the quitclaim deed, which you agree constitutes at the very least the assignment of the mortgage. Once he took possession of that property, he thinking him the owner, you're saying that begins the entry period.
No, Your Honor, because there are other requirements of the foreclosure by entry statute.
Specifically, the filing of a certificate.
Yes, the filing of a certificate of entry, and only that begins the right of redemption.
And I guess
period.
my question to you is, as the assignment of the mortgage from U.S. Bank, with U.S. Bank having filed that, assuming that they did, and I thought you'd written, but assuming that there is a certificate of entry filed at the time of foreclosure by U.S. Bank, can Bevilacqua enjoy the benefit of the time period of that filing?
No, Your Honor. At the time, I believe you're correct that U.S. Bank did record a certificate of entry, but it made entry at the same time as the foreclosure auction, May 16th, 2006. On May 16th, it was not the assignee of this mortgage and had no right to foreclose, whether by power of sale or by entry or by any other means.
So the certificate of entry was, in fact, filed after they had received the assignment. That's what I take it from what you're telling us.
Your Honor, I do not honestly recall.
Counsel, your time is up. Thank you.
Thank you.
Good morning, Your Honors. John Stephan for the Commonwealth of Massachusetts, amicus curiae. While Mr. Bevilacqua's situation engenders some sympathy, he lacks standing to bring a tri-title action, and that, even following from the discussion that we've had already this morning, is apparent. Regardless of his status as a potential mortgagee or as his status as a potential bona fide purchaser. And this is because, in order for him to bring a tri-title action, he must hold a requisite legal interest in the property. The statute refers to record title. The case law under the statute makes clear that record title is not merely having a document on record at the Registry of Deeds.
What is it?
It is, in fact, legal title, and a specific form of legal title, which is, as this court held in O'Meara, shown from the record itself, from an examination of the entire record, to be indefeasible and unencumbered.
Wouldn't that be shown here prior to Ibanez? I mean, we've had pleadings from the folks that actually do these record title searches in Ibanez saying, no, this essentially would have passed muster. So
in this instance, from the face of the record, and not to mention Mr. Bevilacqua's petition itself, but the record itself shows that the foreclosure was initiated in May and that the assignment was not received until some 2 months thereafter. These are matters of the record, the documents on record at the Registry of Deeds. Thus, from an examination of the record as a whole, you can tell that the foreclosure per
So a
bond
title
was
examiner
void.
at the time would have said, oh, this is clearly a defective title. A title examiner would, at the time, now I'm talking about before Ibanez, said, oh, this is clearly defective title. You shouldn't buy this.
The question hinges on what Ibanez held. Ibanez confirmed longstanding legal principles. Whether there was a practice within the community under REBA Title 58 or otherwise.
But that may be
doesn't change
relevant
that.
to whether he's a bona fide purchaser for value. And is it your suggestion that that's irrelevant? Whether he's a bona fide purchaser for value is irrelevant?
Most certainly he is not a bona fide purchaser
That's
for value.
because there's an assignment in the record. That came after the foreclosure.
That's correct.
So
Your Honor.
even
That's
if a
our
title
position.
examiner at the time would have said, no, this is adequate record, your view is that wouldn't have mattered.
If he's a bona fide purchaser for value, he is taking a void document. As a bona fide purchaser holding a void document, he stands in the same position as one who holds through a forged deed. This court's case law makes clear that the holder, even an innocent one, who holds a forged deed.
This is the same as a forged deed?
It is a similar situation, Your Honor, because the forged deed transfers no title. A void foreclosure yields a foreclosure deed that is itself a nullity, and thus someone who takes from that takes a void document.
So let's say we have a situation where, let's just assume thousands of people have purchased in good faith, maybe not bona fide purchasers for value as you would have them, in good faith, purchased from banks who had foreclosed properties. Now, those titles may have passed again and again and again. They are all void. They're all void.
There's
They're
no
all
doubt.
void. And that's a situation that you're comfortable with.
There's no doubt that there are significant ramifications from the invalid foreclosures, widespread invalid foreclosures that were undertaken in the process that we've seen over the past several years.
And it doesn't matter whether a title examiner at the time would have picked this up or not, whether the practice would have been such that this would have been recognized at the time as a void. It doesn't matter to you.
It does not, because there are remedies available. Tri-title is not one of them. Tri-title should not be expanded to a circumstance like that of Mr. Bevilacqua's as a means to address this problem, where there are other adequate remedies, both in law and equity, both within litigation and outside of it, that have stood the test of time through our system, that do not carry with them the negative consequences that expanding tri-title does. There are...
And those are?
Well, for one, Mr. Bevilacqua and third-party purchasers in his position could very easily, could bring an action against their grantors for failing to deliver clear title. That action could...
So they can basically say, we wish rescission and damages, or...
Rescission and damages, or could appeal to the Superior Court in its equitable jurisdiction to fashion a remedy that would result in clear title transferring to the third-party purchaser. And in that...
How would they get that from
Well,
the Superior Court without proceeding with the foreclosure themselves?
Well, first off, a second valid foreclosure is one of the remedies from which the pool of injured third-party purchasers could resort. There are, if conducted validly in accordance with the terms of the mortgage and the statute, a second foreclosure could then extinguish the right of redemption and create, or at least clear title at that point, for the benefit of the third-party purchaser. That could be done independent of an action against the grantor, or it could be part of a remedy that arises through that action. In addition, as has been discussed, foreclosure by entry is available in some circumstances.
But that takes 3 years.
Indeed, but recognize where if a valid certificate of entry and a valid entry were made in this instance and a valid certificate filed, the 3-year period very well may have run.
Well, surely there was an entry here. There was an
question
entry by someone who was assigned the mortgage that was in default.
The question is all of timing and whether or not the entry was made before or after the assignment was
Well, clearly
made.
the entry was made after the assignment. The new purchaser of the deed purchased it in October. That was well after the assignment. So he purchased, at a minimum, the mortgage and all the rights that the mortgagee had, and he entered.
It's possible that I don't necessarily agree with your initial premise that the purchaser takes the mortgage. I don't believe the record is clear from that.
What does a purchaser get then?
Well, the purchaser not necessarily. First, I disagree with the reliance that this has been made today, placed today, on the Brown v. Smith line of cases that says that an invalid or a defective foreclosure transfers a mortgage. While it may be true in those instances, those cases are distinguishable from the one here. Brown v. Smith did not call question. There was no question in Brown v. Smith about the ability of the grantor to transfer the deed of the property.
Why is this troubling to you, by the way, that the transfer of this deed would transfer the mortgage? Why is that of your concern?
Because, only in that it's an open question. The fact that the assignment needs to be specifically detailed, it needs to be in writing, it needs to meet the requirements that this Court has discussed in Ibanez to ensure that the mortgage itself passes.
But you had said earlier that there could be a foreclosure by Bevilacqua. How could Bevilacqua...
Well, it would need to be a unity of the note and the mortgage in whoever was to proceed with the foreclosure.
So you're saying that Bevilacqua may not be able to proceed with the mortgage?
Not individually on his own, without first acquiring the rights to proceed under the debt from U.S. Bank.
So you're But
U.S. Bank.
But it was a quitclaim deed. So with a quitclaim deed, does it not enjoy all that U.S. Bank owns in that property? And if it owns title, it gets title. If it owns legal title, that is the mortgage, it gets that.
It's possible that the mortgage did pass, Your Honor. Yes, I don't believe that there's evidence in the record to show the status of the ownership of the note. And I believe that Mr. Bevilacqua would need to own both the debt.
Right, well, that's the problem, because in theory, the mortgage is held for the benefit of the note, so if you say you transfer the mortgage, you also have to say you transfer the note.
It would seem the opposite, Your Honor. If the mortgagee holds the mortgage for the benefit of the note holder, it is the note holder who has the ability to demand the assignment
Right,
of the
which
mortgage.
means that if U.S. Bank still holds the note, then U.S. Bank is still in theory entitled to the mortgage. So
Yes.
So Bevilacqua we would have to say the quitclaim deed transfers not only the mortgage but also the note for Bevilacqua to be at peace with being the true mortgagee.
That's correct, Your Honor. At that point, Mr. Bevilacqua would have the ability to proceed with foreclosure. It is also possible that between them, U.S. Bank and Bevilacqua could ensure that the note and the mortgage were unified in either of them, giving U.S. Bank either the ability to proceed with the foreclosure or Mr. Bevilacqua, depending on how the papers were aligned. Assuming they were, then free foreclosure could occur, the right of redemption extinguished, and clear title would follow. So these are at least two of the remedies. In addition, there's the other remedy, which is, to our experience, being pursued by a number of folks and practitioners, simply to obtain a release from the original mortgagor. This doesn't require the full-blown litigation. It may require some exchange, some compensation to the borrower for releasing, signing over their rights under the initial deed, but it could prove more efficient in many ways than full-blown litigation. That is a remedy that remains available to borrowers in to purchasers in Mr. Bevilacqua's situation. We urge the court not to create new remedies. Expanding tri-title is a new remedy, one which carries with it adverse consequences.
I guess one more question, if I could. Let us assume, for the sake of this argument, that Bevilacqua has been assigned through the assignment to the quitclaim deed, been assigned the mortgage and the note as well, and wishes to foreclose, and then files also a certificate of entry. Can Mr. Rodriguez say, I'd like to move back in while the foreclosure is pending?
It would, assuming that the notice requirements are satisfied, the usual process would follow. And Mr. Rodriguez, with the certificate of entry having been filed, if assuming that the statutory requirements under the foreclosure by entry statute have been met, the foreclosure would occur at the time of the entry, as was argued earlier.
So the answer of Bevilacqua could say, I filed a certificate of entry, no, you may not move back
Well,
in.
Mr. Rodriguez would have the rights then under the, that he would have during the period of the 3-year period that would follow from the recording of the certificate. He would have the ability then to come forth and redeem to regain the access to the property.
But can Bevilacqua take possession without the note?
I would argue no. Mr. Bevilacqua must have the note.
He doesn't have the note.
I don't believe that he has the note. He may have, yes, I don't believe he has the note. I don't believe that the record is clear on that. But he must show, in order to foreclose, you must show inherent in any mortgage, you must be able to show the default condition. Without the note, it becomes very difficult to demonstrate that. Mr. Bevilacqua is not necessarily in a situation to be able to show that Mr. Rodriguez has failed to actually comply with the conditions incumbent in his mortgage.
Counsel, your time is up.
Thank you, Your Honors.